Hi, my name is Kristen Olson. I work for Stange Law Firm, and I'm going to be talking to you today about how to avoid having to deal with the ARDC through your communications. The first tip today to help you deal with communication is to write monthly status letters. These letters are regarding the case for the client and what's going on. The preamble of the Rules of Professional Conduct says we are to be prompt, diligent, and communicative, and that we are supposed to communicate with our clients. The best way to communicate with our clients is to make sure they know what is going on in their case and putting it in writing. The way that we do our letters to make sure that our clients know what is going on is we tell them what is going on in their case. We explain to them whatever is happening, so like if there's discovery going on, why we need it, what it's there for, and why they should do it. If they have a court date coming up, we make sure they know when their court date is, and then we make sure to put any other relevant information as to what is going on in their case. We do this so that we are maintaining contact with our clients at all times, and they always know what's going on in their case. The second tip to help you to avoid dealing with the ARDC regarding communication is to return phone calls timely. Attorneys in the past have gotten in lots of ARDC trouble for that because what happens is a client will call, and they will call, and they will call, and the attorney will never call them back. In one case, in Ray Marcostas, we have an attorney who started a case in 2013. His client had attempted to reach him all through 2013, from April of 2013 until December of 2013, and he was unable to reach him. The ARDC ended up suspending Mr. Costas partially for that reason. What we want to make sure that you do is to return phone calls in a timely fashion. Now, what does that mean? Does that mean within 24 hours? Does that mean by the end of the business day? Sometimes it depends on the client. If it's an important question, you may want to return it by the end of business day. What I do is I return phone calls by the end of the business day unless there's something going on. Then I still return them within 24 hours because otherwise you get unhappy clients. And what does an unhappy client mean? It means a bar complaint. The third thing that you can do to avoid an ARDC complaint is to return emails promptly. We are in an age now where digital communication is extremely important. Part of that is knowing when to return emails and when to draw the line with your clients. Emails, text messages, that might be something that you do as an attorney. But where does that end? Do we allow Facebook messages, Instagram messages? As attorneys, we should draw the line to make sure that we are using email and returning them promptly because many people don't check their Facebook as much as their email and may have a Facebook message sitting out there from several days and not even see it. So what we want to do is to make sure that we are prompt and diligent when dealing with that and making sure that we can communicate with our clients. One way to do that is communicating with them and saying, hey, we use email and you can email us, but please don't use any other form of electronic communication. The other reason this is really important is unlike email, other forms of electronic communication are not nearly as secure. And so what that can fall into is a whole nother problem of having to deal with the ARDC about, hey, somebody hacked my Facebook account and now know information about my clients. So please make sure that you are returning emails as soon as possible. If not, that day, within 24 hours, or if you're on vacation, when you get back or have an alternate number to reach you. The last thing I want to talk to you about is how to explain the case to your client. One of the things that we as attorneys have to deal with is we talk to attorneys on a regular basis using the fun words that we learned in law school. We can't talk to our clients the same way. The clients don't really care or know what we're saying when we say discovery needs to be done or we're going to file a motion to compel. What we have to do is we need to break that down for them. This is what discovery is. This is why we are doing it. This is what it is for. This is where it goes. This allows them to ask any questions that they have that they might not otherwise feel comfortable asking. What it also does is allow for us to keep in communication and have our clients feel like they can trust us to come and ask us questions. What we really need to do is make sure we're realizing that we as attorneys are not talking to other attorneys when we talk to our clients. We are talking to people who may need to help understand what is going on. They don't go through this on a daily basis. So make sure you're explaining, hey, I went to a case management date today. This is what a case management date is. It's where a bunch of attorneys go into a room and they talk about the cases, and then they see where they're at in the case and decide if they need a hearing date or whatever kind of court date you're going to. Because if the client's not there, especially, they really need to understand what you did and why you did it. Otherwise, they don't know what's going on. And so make sure you're explaining the steps and the processes of your case to your client as you go through. I hope these tips for the communication and avoiding the ARDC are helpful for you. For more information on avoiding the ARDC, be sure to check out the ISBA book, Rules Governing the Legal Profession and Judiciary in Illinois, which is available on the ISBA's online bookstore.